content has no shape. And Lucy's tight box comes in first. Lucy does dabble, Lucy does Dabbleverse, she does dabble, Lucy does Dabbleverse, Lucy does Dabbleverse. Lucy tight box brings the facts, and she breaks them down for us. Lucy does Dabbleverse. La la la, Lucy has a tight box and she shares it with dabblers. No, not like that, but she does this show for us. Lucy does dabble, Lucy does Dabbleverse, 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 yes she does, yes she do it, Lucy does Dabbleverse, yes she does, Lucy does Dabbleverse. Lucy does Dabbleverse, she does. Lucy does Dabbleverse, she does. Lucy does Dabbleverse.
Hello, everyone, and welcome back to Lucy Does Dabbleverse with the most important guest that we could ever possibly have, Luigi Greenberg. Luigi,
hello!
Thank you for being here. I am so excited to talk more about our favorite Lolsuit with you.
Well, I've been like really excited to do this ever since last Monday. Thank you for having me, and thank you for giving me this opportunity to have so much fun.
Listen, I would be nothing without you. So this is my honor, truly. I am so excited. I feel so excited that we get to be talking about this incredibly crazy lawsuit where Stuttering John is suing our buds, Karl and Shuli. That's right, we're biased about this. But now we get to talk about it with lawyer Luigi Greenberg and, less important, paralegal Lucy Tightbox.
Whatever.
Whatever.
You are the brains behind the operation, and I have no shame in whatsoever in saying that you are a smarter person than I am.
Oh, well, thank you. I do have to admit, though, I am very dumb, and I have to apologize to everybody about some dumbness that I posted on the internet this week. So you and I started talking about this lawsuit last week, and after we started talking about the lawsuit, Stuttering John, through his attorney, Tabor Benedict now, filed his amended complaint. And I was very excited to compare the amended complaint to the initial complaint. In fact, I printed them out and I redlined them like a truly good paralegal. That's what we do. So, because of that, I thought that there were some changes that didn't even exist. So I thought that we would start off this episode before we get into some FAQs that both you and I have been getting, talking about the differences between the amended complaint and the initial complaint and what those documents mean and why in the heck this happened.
I don't think we're ever going to find out why this happened.
Yeah. All right. I gotta define the changes before we can figure out why it happened. So the only changes that happened are Tabor Benedict corrected the spelling of his own name. You might recall that in the initial complaint, he spelled his name Tabor Beneduct on a signature line, which is bonkers stupid.
I'm still I'm still like just completely baffled by that.
It's mind-boggling. Have you ever misspelled your name? Like, not like on a signature line in particular.
I have not.
And if you did, you would notice it immediately, right? Because you know what your name looks. Whatever. All right. So he changed he corrected the spelling of his name, so he now is officially Tabber Benedict. We're very excited about that. And in addition to that, the only other change that was made was that in the caption, in the defendant's portion of the caption, he added AKA Shuli, as opposed to the initial complaint, which just said the Shauli. I can't pronounce it in the correct way that everybody pronounces it when they're making fun of Shuli. That's all that was changed. Those are the only two changes between the two documents. I initially thought and posted on Twitter that there were a couple of changes after paragraph 99. I thought that I saw some changes in language. I thought that I saw some additional case law cited. I was totally wrong about all of that. Nothing changed. I got overly excited.
I have to assume that Tabber Benedict was just simply embarrassed and just wanted his name changed.
He got blown up by the fact that he had his name spelled wrong because, again, it's so incredibly bonkers. I just cannot imagine making a mistake like that. So
it is really mind-blowing.
Cat attack. Apparently we're having a cat attack right now, so apologies for that. He has broken into my room and is trying to drink my coffee. Wonderful.
He is jealous and needs attention.
He needs very much attention right now. That's Booger, for anybody who has not met Booger before. All right, so let's talk about what this lawsuit is a little bit. Again, we are going to be getting into some case law that looks at what this case is talking about. In addition to that, we're going to be getting into a ton of FAQs. We're going to be talking about things like, were the Kate Meany phone calls legally recorded? We're going to be asking questions like that. So please send in more FAQs as we're going along. We would love to be able to answer your questions. We've gotten so many of them, so many great ones. We have tried to compile as many as we could, but we know we missed stuff. So please hang out with us. Let us know what your thoughts are. Let us know what you want us to clarify. But before we do that, we do need to talk about what exactly this lawsuit is.
Garbage.
So bingo. Podcast over.
Yep.
Done.
Good night, everybody.
It's great seeing everybody. No, this lawsuit is a suit where, again, Stuttering John is going to be suing both Karl and Shuli and Who Are These Podcasts and TSN. And this lawsuit is based on New York civil rights law sections 50 and 51, which deals with the right of privacy and publicity. So section 50, I kind of want to break these down a little bit because I don't think we really did that during our last episode. Section 50, what it does is it makes it a misdemeanor to use a person's name, portrait, picture, likeness, whatever, for advertising or trade without written consent. And then section 51 builds off of that, which creates a civil cause of action, letting the person who is injured, monetarily injured in this case, sue for an injunction or damages. So that is what this lawsuit is based about. And of course, it relates to DabbleCon 2 and Dabble House, where Karl and Shuli and many, 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 many other people played the infamous Kate Meany tapes and allegedly used John in the promotion of these events in order to sell tickets. Did I get that right? You give me your interpretation of the lawsuit.
I'm going to say that John spends way more time bitching about being made fun of than actually stating any sort of legal argument.
Yes.
There's so much wasted space, and for a good cause of action to be stated, you really have to be very, very precise, direct, and there's none of that. You have to lay out the elements of the statute that you say was violated. You have to actually show exactly how each element was violated. He doesn't do any of that. All he does is bitch the whole time about how he doesn't like being the center of their attention and being mocked. And I believe the total was 31 pages. Let's just say 30. I'm going to say his argument could have been summed up in maybe 3 or 4, but he just decided to keep rambling about nonsense, about things that were completely irrelevant. No lawyer would have included some of the things he said because they're completely irrelevant. And then also just diverting to other stories that are irrelevant. I mean, there's so many claims in there, but the only thing that he actually uses as a cause of action are the right of publicity. It's really odd
to everybody. So, will you explain to everybody what a cause of action is and why it is important?
Okay, sure. So when you sue somebody, you can't just say that you're suing someone because you don't like what they did. You actually have to state that they, in fact, violated a already enumerated and stated law, meaning it has to be on paper somewhere. And then every law has its own set of requirements in order to be violated. So, in other words, the term murder, you can't just go and say someone murdered. No, you in fact have to determine what the elements are murder. And that means, I'm being very hypothetical here, but it could mean taking a life. It could be, and there are degrees. It could be taking a life in certain circumstances, certain contexts. There's a lot that has to go into it, but every element that is in that law has to be satisfied. Let's just say 3 to 4 different things all have to have happened in order for that law to be violated. So when you state a cause of action in a civil court, you have to say this law was violated, here is how it was violated, and here is how each element was satisfied in order to equal the violation. John doesn't do that. He just says, he uses words like illegal. He uses words like trespass. No, those are legal words that all have to be proven and substantiated and explained. And then he uses right of publicity. Well, he doesn't actually explain the lawsuit. I'm sorry, he doesn't actually explain the statutory requirements for a violation of right of publicity, nor how those elements were satisfied. So there you go.
Yeah, that's absolutely true. And I think you explained that perfectly. Now, you did bring up a word that really makes me want to talk about something, which is the word trespass. Also, since you and I did our last stream talking about this wonderful, wonderful lawsuit that is so perfectly written and we all love so very much, there was a New York Post article. So there have actually been a couple of different news write-ups. TV reporter Will Heron, I know, wrote an article. I think he was the first one to the game, and I believe that he is a dabbler, so that was very exciting.
He was on my show on Friday.
That's
we talked
wonderful.
About it. Yeah.
Oh, I missed it. I've been doing too much. My goodness. And then we got this lovely New York Post article that is just hilariously wrong. There could not be more incorrect things in this article, and my favorite of which has got to be that Karl and Shuli themselves trespassed onto John's property in order to steal his couch cushions. Now, we know that that's not the story of what happened. What's your understanding of the story that happened? That actually, how did the couch cushions come to be, Luigi?
Okay, this is actually kind of a long story, so I'm going to try my best to...
I'll zip you along.
Okay, please. All right, so there was one particular dabbler who lived nearby. And I've spoken to this dabbler, and she said, you know what trashy people do? They throw all their trash out onto their curb when they move. I wonder if John did that, because he's a scumbag piece of garbage. I'll bet he does what scumbag piece of garbage people do. And it turns out she was right. So she took pictures, sent them to, I believe, TSN. I could be wrong about that. TSN thought it was hilarious and said, would you mind taking them? And she said, I'm not touching those disgusting, filthy, scum-ridden sheets, pillows, cushions. And then somebody else came around and then took them. They were on the curb.
We have a very committed fan base.
We do. And we also have photos. Yeah.
I would not ever have touched those things. I was within 1 foot of them, and that was too close for me.
Nope. No telling what sort of Ebola-type viruses are on those cushions.
No.
But that is how I understand the story. And there are lots of photos to substantiate that. And someone else came and got them. But what John's lawsuit says is that someone trespassed on his property. Well, here's the thing. John had already moved out of this place and he dumped everything on the curb. So he's wrong on two different counts. He's wrong that it was his premises, and he was wrong that anyone trespassed. That was something he discarded, no longer belonged to him. It was on public property, and someone came. So I really do believe that there should be a point made in the response and the motion to dismiss that John was blatantly lying.
Well, let's also not forget, I could not agree more with what you said, but let's also not forget that the New York Post was also blatantly lying, because in their version of the story, not only did this happen, but it was Karl and Shuli themselves. They traveled to LA and they did it. And that is the funniest. I imagine them cat burglaring their way up to the curb, which is...
I see them both wearing black turtlenecks and then little black caps on their head.
It's my favorite mental image right now. I just play that in my mind before I fall asleep, and then I have nightmares. That's great. I love it.
Right, of the cushions.
Yeah. So Luigi and I did already do a pretty thorough breakdown of the lawsuit itself. So today we are not going to be doing a breakdown, but instead I want to talk about some case law. And I am really excited to share some of this with you because, again, we've kind of talked about, both as an attorney and a paralegal, we do a lot of work where we're just kind of looking at other cases that are similar. So I dug up some similar cases to this because I was wondering if they might shed some light onto this particular case. So I found some cases that have all already been decided, and I want to get a little bit of your input on these.
Great.
Yeah. So the first case that I found was a case called Cohen versus Hallmark Cards. And this was a case where Hallmark used a model whose last name was Cohen. I can't remember her first name. I want to say it was Louisa, but that sounds like an ugly name, and she was a model, so I'm sorry to the Louisas out there. I don't know. Somebody Cohen. Hallmark used a photograph of her in a greeting card without her consent. However, the image was altered into a humorous, one of those talking cards that are really annoying that you have to pretend that you like from your friends.
Yes.
And they portrayed her as a comic skit within this card. So Cohen ended up suing under New York Civil Rights Law Section 5051, which is exactly what this lawsuit is. That's exactly what the John versus Karl and Shuli lawsuit is. This should be protecting against any unauthorized commercial use of a person's name, portrait, picture, likeness, etc. But New York County, which is exactly where the Stuttering John lawsuit is venued, in that court, Cohen's complaint was dismissed. It was dismissed because the trial judge held that a card was parody. The card was parody, and therefore it was constitutionally protected under free speech, so under the First Amendment.
Amazing.
Interesting and exciting, right? And you're yay, everything is wonderful. However, unsurprisingly, with a lot of lawsuits, it ended up going to the appellate division. So in 2007, it went to the First Department of the Appellate Division. And what happened there was that the court held that Hallmark's card was, in fact, commercial use of Cohen's likeness. So it was used in order to sell greeting cards. And therefore, it was not protected by parody. So they ruled that Cohen had a valid claim under Section 51, and they reinstated her lawsuit, then taking it to the New York Court of Appeals, who affirmed the appellate court's decision.
Interesting.
Very interesting case. Very, very interesting case. Now, what I think is particularly interesting about that, we haven't really talked about the court system in New York State and how it works. John's lawsuit is filed in New York County Supreme Court. When people hear the word Supreme Court, they think that's a really high court.
Right.
In New York, that's the lowest court.
Yeah. It's a naming. It's every state is allowed to name their courts whatever they want. And the highest court in New York is the Court of Appeals, right?
Correct. Yes.
Yeah.
Yes. So this, at the lowest level, at the exact same court that John has taken his lawsuit to, potentially with the same judge once the judge gets assigned, the court said, absolutely not, this is garbage. When they appealed up, that is when the court started saying, hey, maybe this does actually fall within a valid Section 5051 claim. So where does the court draw the line? Because like I said, I looked at many, many cases. And I'm going to try to summarize kind of what I found out.
Yeah.
The reason that Hallmark versus Cohen was a violation is because selling a product with somebody's face on it just to sell it can be considered a violation.
Right.
But if the likeness appears as art, commentary, or expressive works, commentary being a hugely key factor in this case, even if those works are sold, so even if you are selling something, as long as there is commentary, it is usually protected under speech and not considered commercial exploitation under Section 51.
Yeah, I mean that really does sound exactly like what the defining factor is, specifically because without really naming any other issues, when you study the First Amendment in law school, it really is about commentary and basically holding something up for a different audience. Simply using a picture and attaching a song to it without making any actual point towards the subject matter is very, very different than actually having a subject matter and transforming it for a different audience. The most famous case that we studied in law school was Falwell versus Hustler magazine.
Yes,
in
absolutely.
Which the issue there was that Jerry Falwell was butthurt about Larry Flynt writing an article that was obviously parodied about Jerry Falwell having a sexual relationship with his mother. And the whole point was just simply to have an audience to laugh at Jerry Falwell without actually meaning any of this stuff. Yeah. And guess what? Falwell lost. Yeah. Larry Flynt walked away a champion of the First Amendment because he had transformed the images of Falwell for a different audience for the sake of parody and satire. So,
absolutely,
still confident about the facts in this case.
I do think that this is a really interesting case. A lot of people have been asking us questions about, like, is this just outright a frivolous lawsuit?
Yes.
And my answer to that, my answer to that is actually no. I don't think it's outright a frivolous lawsuit. Do I think that there is? Do I think that they're going to win? Do I think that John is going to win? No. But I don't think it's entirely frivolous. I do think that it mirrors some of the commentary that was made in the Hallmark versus Cohen case. I think that there are similar cases which have been both won and lost. I will tell you right now that based on my readings of Section 5051 lawsuits, they are harder to win than I expected them to be. Most of them don't win until they take it up to those appellate divisions in the New York Court of Appeals. So a lot of the time in these lower level courts, which is exactly where we are right now with John's lawsuit, it's unlikely that the court is going to side with him. Now, is he going to appeal a dismissal if he ends up getting dismissed on the lower level courts? That costs a lot of money.
I was going to say, if he has a pro bono attorney, then maybe, like with Michael Popak.
Can you honestly imagine? Okay, let's assume that everything is on the up and up, and Tabor Benedict truly is his attorney. Even if Tabor Benedict is a pro bono attorney, do you think he's going to take it up to the appellate divisions if he loses? Yeah, Tabor won't want to do that. There's not enough publicity in it for Tabor. Tabor has already made a fool of himself. And so Tabor, any chance that he had of getting additional clients out of this were probably gone with Benedict.
I went on a long rant about this on my show on Friday with Mr. Will Heron. And Will Heron asked a couple of questions that were similar to this. And I had to say that when you boil down the elements of what's going on here, that is that John has an attorney who has spent a few years in prison and is now trying to build up another law firm There are some practical issues you have to take into account, and that is that while he is trying to build this law firm, does he have the resources to focus on John's nonsense for no pay? His priorities will most likely want to be focusing on paying clients as he is attempting to build this new law firm. And for that reason, I can't help but think that very soon after this response and motion to dismiss is filed, we're going to hear that Tabber Benedict is no longer John's attorney. My thoughts.
I think that that is a really interesting point. And a lot of people have asked this question, and I didn't include this on my list of questions, so I'm glad that you just reminded me about this. People have been asking, is Tabber even legally allowed to practice law? Shouldn't his attorney registration have been revoked because of his years in jail for hit and runs involving, oh God, I don't even want to go into his malarkey. Yes, he was reinstated by the court. So what I have pulled up here on the screen, this is actually showing that Tabber Benedict is currently in good standing with the court. He is allowed to practice law. He is currently registered. He has an effective date of being registered as of 11/21/23. And the reason for that is because he actually had to petition the court. So let me just pull up another file. He had to petition the court in order to get approved to be able to practice law again.
Yep.
And so this is actually the order where he is now allowed to practice law. So yes, Tabber is allowed to practice law. Yes, he is currently an attorney in New York State. And I know a lot of people have been wondering about that. This basically says that a referee was used to look at his case. A referee within law is exactly like a referee within sports. It is an unbiased person. They don't work for the court. They don't work for the plaintiff. They don't work for the defendant. They don't work for anybody. Well, theoretically they don't. Let's be honest. Everybody's biased. But it is supposed to be an unbiased person, and the referee in Tabber's case recommended that he was able to practice law again, and the judge agreed, and he was reinstated into New York State to practice law. Yep. So that is a
something you just got to think about. I mean, if you had a business and it got taken from you and you had to restart from the ground up, and some dickhead comes around saying, can you do me a bunch of favors and do stuff for free and focus double digits of hours, maybe even triple digits of hours? No, not at all. I'm not doing that. Yeah.
And in addition to that, let's not forget, Tabber also has his AI workout business or whatever the fuck it is. So
I don't know what that is.
He's got a lot of things going on. I cannot read any of the words that he writes, including in this lawsuit. It was very challenging for me, even though they tried to dumb it down.
If you have not seen the new Naked Gun movie, there's a gag in it that actually did kind of remind me of Benedict.
Tabber.
Yeah. Have you seen it? Have you seen it yet?
I haven't seen it yet. I'm so behind.
There's a scene at I believe it's supposed to be parodying Crypto.com Arena, which I believe is a real thing. I'm not totally sure. And there is just this frame that shows the arena and it says PonziScheme.com Arena. And I just laughed at that because that's kind of what I think about crypto. But then I thought to myself, who else really believes in crypto? And I don't know why my mind jumped to that, where I was like, Tabber, all those fancy fucking AI nonsense bullshit words that he's using on his website, I'll bet he's a huge crypto guy. And
Listen, I'm also a huge crypto person, so don't shit on us crypto people. We love it. It's fine. Everything is great.
It's a giant Ponzi scheme.
I'm just going to... I want to say an extra special thank you to somebody who's in the chat right now, and then we're going to read a couple of super chats, and then we're going to get into the FAQs. DJ Electra Fry is in the chat right now. And I want to say a huge thank you to her because she created my new intro for Lucy Does Dabbleverse, and it is beautiful and wonderful. Make sure that you go check her out, both on Hack Ride's channel and on DJ Electra Fry.
My friend and mentor, DJ Electra Fry.
Yes, absolutely
love her.
Amazing. Truly, truly incredible. And the creator of the P-Break song, which I love so very much.
And the creator of the theme song to my latest little venture, the intro song to LGBTQX, I'm Not Gay is the name of the song.
I couldn't think of anything more perfect. All right, let's check out a couple of super chats here. Thank you so much, Delta Zero, for the $1.99 super sticker. Greatly appreciated.
Delta Zero.
Wonderful.
Thank you.
Next up, we have Crusher17 with $2 Canadian. Look at VTL versus SJ lawsuit. Look at 39 wording. Ooh, I'm interested in that.
VTL versus SJ lawsuit.
Do you have a copy of that lawsuit, Luigi?
I don't.
All right,
No.
hang on. I'm going to pull that and I'm going to send it to you, and then maybe I can charge you
All right.
with maybe I can charge you with looking at that while I read.
I don't need to be
these.
convinced that this has Vince's fingerprints all over it.
Yeah,
I mean,
that's a good point. That's a good
yeah.
point. That's a very good point. I think we can all agree on that one. Donna G is in the chat. Thank you so much for the $19.99. Rushed home to catch this live. I'm making my donation
Donna
to fund
G.
this Dabbleverse nonsense. Donna G, you are so greatly appreciated. Thank you very
Thank
much.
you. Thank you. Thank you.
Tony from Hack the Movies can take his $2 back, goddammit, because he says, Rob K, get out of the chat, #Boys Month. Tony, I literally reviewed Greasy Strangler for Rob K. What have you done for him recently is what I would like to know. Also, my Greasy Strangler review comes out tomorrow. Everybody come and check that out. I'm very excited about it. Also, hi, Rob K. I'm glad to see that you're in the chat. Next up, Delta Zero, another $1.99. Thank you so much. How much will they realistically lose Karl and Shuli? That's a good question.
That's
We
a
have
great
some
question.
Similar questions to that.
Yeah.
We have a lot of questions relating to what are the legal fees that they're going to have to pay? Can they recoup those? Lots and lots and lots of questions about things like that. I think I want to put a pin in this for a little bit, Delta Zero.
Yeah,
I
yeah.
know you're itching
We'll
for
get
an
to it.
answer. That's a big question. That's a
Hey.
really, really big question.
I had someone actually mention to me you might want to turn your gain up just a tiny little bit. They say you're a
I'm
little
a
low.
little quiet. Oh,
Yeah.
boy, oh, boy. Let's fix that right now. Let's do that. Is that better? I'm hoping that it is. Thank you for letting me know.
Yep. Sounds.
Hopefully that's a little better.
I think that sounds
All
better.
right, cool. Yes, awesome. Wonderful. All right, next up, we have Rumpled Trenchcoat, a Columbo podcast for $5. I think SJ would have had a much better case if he was suing on the grounds of, I'm really embarrassed.
There's more credibility with that.
I believe him when he says that. If he ever were to say that, I would believe it. That's for
Yeah.
sure. That is
Yeah.
for sure. Next up, we have Raper Butt, the absolutely incredible Raper Butt. Of my legal friends, Luigi, it's you and Raper Butt. Raper Butt is also great at all this legal malarkey. And he says, Hi, John. Hi, John's lawyer. Yay.
I'm in good company with Mr. Raper Butt.
He's great. He's my favorite. Him, Mrs. Purbutt, absolutely wonderful. Rumpled Trenchcoat, a Columbo podcast, $5. Thank you so much again. All I know about the couch cushions is that I took a picture with producer Chris's phone of Kaylee and Chris doing Vanna White poses in front of them at DabbleCon 2. That is true, and it is one of my most cherished pictures, actually. Except for the fact that it reminds me that I was really close to those couch cushions. Ugh, gross.
I as much as I understand the novelty of getting them, I wouldn't have wanted to be anywhere near them.
I know people have been sharing their pictures. I want to see everybody's pictures of them with the couch cushions. So tag me on X. Tag both me and Luigi on X. I am once over Kaylee Cayley, and you are Papa
Underscore Electrico. Yeah.
Electrico. Yeah, tag us. We want to see your couch cushion pictures. I think they're hilarious. I know Tony from Hack the Movies just recently posted one. Tons of people have been posting their couch cushion pictures, so I want to see them. I will dig up that one that Rumpled Trenchcoat took of me. Big Daddy Dodo. Hello, Big Daddy Dodo. $4.99. Thank you so much. The cushions in question. Oh,
gross.
I couldn't have possibly. I didn't even look at that. Wait, I have to get
It gave my computer a virus.
Yeah, I feel dirty now. Just wonderful. Oh, my God. That's so funny. Rumpled Trenchcoat coming in again for $2. The cushions were pretty gross. That is true. There were black lights on them, and I felt disgusting to be near them. Hamhead, the amazing Hamhead. How's Dabble House even mentioned in a New York Lolsuit? That's a good question.
Hamhead.
And we have not been asked that question yet.
We have not. But
Luigi,
great question.
Do you want to start out with I think I have an answer, but I'd love to hear what
Okay,
you
sure. John is dumb. There's no reason. There's no reason it should have been. But John is dumb. And we have already established that he does not. I'm going to just keep saying he, because I'm convinced that a lawyer did not write this. I don't think a lawyer wrote this. I think John was allowed to write this, and Benedict put his own name on it. So I'm going to say John does not understand anything about jurisdiction, doesn't understand anything about the law, doesn't understand anything about the English language, and wrote that. But I believe that this should be something that is immediately argued against in the response in the motion to dismiss, that the Dabble House issue is not in the proper jurisdiction of New York State. So, yeah, you're right, Hamid. Doesn't belong.
It is not in the proper jurisdiction, but in addition to that, I do want to point out that there are sometimes, and you can correct me if I'm totally wrong on this, there are times where you need to establish a basis of additional facts. So again, the lawsuit talks a lot about the couch cushions. It talks a lot about the tapes being illegally recorded. It talks a lot about these other kind of ancillary facts. There are times where ancillary facts could be important to a lawsuit, and that could include something like Dabble House. I don't think that it does in this case, but it could theoretically. And honestly, of all of the ancillary facts that are included in this lawsuit, that's the one that I find the least egregious, even though it is entirely in the wrong venue. In my opinion, the whole lawsuit is in the wrong venue because it was filed in New York County as opposed to being filed in Monroe County or someplace that is logically correct.
100% agree. And if you notice when I respond, I do kind of curb my answer instead of saying, simply it won't be or something like that. I say they should argue against that because you're absolutely right. And like we said in our first episode, you get the wrong judge on a bad day. You don't know. And it's funny. I haven't thought about this in years, but I was actually talking about this with someone yesterday. When we talk about catching a judge on a bad day, I once had to go to court with something that was so definitively wrong. And it was a black and white issue. There was no room for any sort of interpretation at all. And I asked the judge for something that my client was completely entitled to as a matter of law, as a matter of precedent, as a matter of jurisdiction. I mean, everything fit precisely. And the judge literally said, the last time that I granted something like this, it got kicked back and I got embarrassed. So no. And I had no recourse. I could have spent thousands of dollars to try to appeal one silly, stupid thing, but it wasn't worth it given the value of the case. And I was literally stunned and speechless that he was so honest and just said it out loud. Told me right to my face, look, I believe you and I think you are right according to law. I don't want to take the chance that I'm wrong. And that happens. It does happen. So there's always room for error. No matter our certainty, there's room for shithead judges like that who might think John has a case.
Well, not even just shithead judges, but judges that don't want to make waves.
Yeah.
It is really a lot of the time, like you just said, the judges don't want to. The example I always use is the judge didn't get a blowy that morning, and so he woke up on the wrong side of the bed, and so that's why he's being a jerk. But there is much more of a case also that they don't want to make case law. They don't want their decision to get pumped up to the higher courts and then for them to be made to look a fool. They don't want that to happen. And so making decisions on cases like this one specifically are really challenging for the judges. And that's gotten us a little bit off topic of the question relating to Dabble House, but that it does kind of all tie around because you have to kind of look at everything that is within the case, and that's one of the reasons that things like this get mentioned within the case.
Yep, totally. I couldn't say it better. Yeah.
All right, Pony Power 2 coming in for $5. Thank you so much, Pony Power 2, the absolutely incredible, one of the best creators in the world, the creator of the Stuttering Johnson, which tortured me and still sits on my shelf and tortures me constantly.
I remember that.
Oh, yeah. You can see videos of it on my Patreon. It's, anyway, Pony Power 2 asks, what piece of anatomy would you need to put John's head on in order to receive a lawsuit? Is that what that says? My glasses are not on, and I feel like I read some words.
That is what it says.
Well, I don't understand the question at all.
I don't
Pony
either.
Power 2.
I don't think I get it.
Oh,
What
no,
piece of
Pony Power
anatomy would you need to put John's head on in order to receive a lawsuit? I'm sorry, I don't get it.
I feel like it might be sexual. I'm gonna go with sexual, only based on the Stuttering Johnson.
I think he's asking if you want another dildo of John.
Yes is the answer. Yes,
Okay.
yes, 1,000 times yes. Actually, I would like one of Tabor Benedict now. I'm very curious about that. It feels slimy for some reason.
That one seems more like it belongs in like a Warren museum. Like it looks haunted and gross and
I don't like where this conversation is going.
yeah. I don't
Shmuel
know.
Buckman, thank you so much for the $1.99. Can you clarify pro bono versus contingency attorney? That's also a great question. Luigi, you want to start off with the answer?
Sure. Pro bono simply means you're donating your time as an attorney and you do not expect any kind of payment. Of course, there can always be some sort of arrangement made where you simply say, I will take care of 100%, or you can say, I'll take care of 50%, or, I need you to take care of expenses, something like that. But essentially free. Contingency means that you only make a profit if you are successful to get your client a profit. One of the biggest places you see that is car accidents, where they say we don't win, we don't take a fee unless you win. What that means is that if you have a contract that is set up with your client beforehand, and that dependent on what they receive, you will receive a percentage of their settlement outcome.
That is perfectly said. I have nothing to add to that. Great job.
Great.
Yeah, yay. Dang Lizard coming in for €2. Why is Shuli's acronym still SH? Did he marry Karl? I'm going to answer the second question first. I sure damn hope so, but also if I was not invited to be a flower girl at that wedding, I am going to be very, very upset. I have a theory about this.
I want to be the ring bearer.
Yeah, we can walk down the aisle together. It's going to be adorable. I do have a theory about this. So what Dang Lizard is referring to here is that in the lawsuit, there are two different acronyms that are used. So Karl is KH for Karl Heberger, and Shuli is SH, which should be logically SE for Shuli Egar. My theory on this is just that a lot of the time people will use the first two letters of the first name, and so that's where SH is coming from. That's kind of my best guess on it. I do think that it's sloppy work, but I don't think that it's anything totally egregious.
I believe that so many of these questions can be answered with the exact same response. John is dumb.
Yes. Karl said it perfectly in the New York Post article. Next up, Karl for $1.99. Can Shuli and Karl countersue for
attorney fees?
Attorney fees. Thank you.
Okay. I'm going to just say this might be one we want to put a pin in.
I want to put a pin in this one. We have a lot of answers to this.
Yeah.
What I want to say to answer this question is anybody can sue for anything anytime. I can file a lawsuit right now against Luigi for no reason whatsoever. I can do it. I'm not going to because I'm going to lose. It's not can you sue. The question that we want to be asking is could you potentially succeed? And so that is the question that we will put a pin in and answer very shortly. Dang Lizard, another €2. Thank you so very much. By the way, Stuttering John has a playlist promoting TSN on his channel. That's so nice of him.
So does Rob Saul.
Wow. What generous guys. I just love it so much. Easy Cartman, $5. Thank you so much. If VTL is involved in these lawsuits, how does he not get fined or sanctioned from the New York State Bar? Isn't there a code of ethics that needs to be followed? I completely agree with that. I think that the answer is that as of right now, we don't have any proof of actual wrongdoing.
Right.
Would you agree with that, Luigi?
It's pretty much it. It needs to be in some sort of official capacity. It's just a practical matter of trying to prove it.
Yes. And do I think that by the end of this lawsuit, we might have that? Yeah, I kind of do.
I kind of do too. Yeah.
Yeah. And sanctions are something that I think is entirely possible within this lawsuit. Luigi, would you define for everybody what sanctions are?
Essentially punishments, a slap on the wrist or disbarment. It can be a full range of anything, but instead of just simply saying punishment, it could be a matter of restricting your access, in essence, grounding you to certain things, not being able to practice for a certain amount of time, but also they can take your license away. If anybody out there is kind of interested in ethics as a lawyer, I would suggest you look up the life of a man named Roy Cohn, Cohn, one of the most fascinatingly diabolical, evil human beings to ever walk the earth. He was a lawyer with no morals whatsoever. And by the end of his life, he was completely disbarred for doing horrible, horrible things. But all believing that he was not necessarily subject to sanctions because he thought he was doing things in the best interest of his clients. That's an odd preview, but seriously, fascinating story. And he's probably going to be a subject of my show eventually.
Yes, I think that would be a wonderful one. I would want to listen for sure. All right, next up, Karl, $4.99. Thank you so much. John, a resident of Florida, is suing Shuli, a resident of Alabama, out of the state of New York. Absolutely, venues and jurisdiction of this case make no sense whatsoever, but the whole reason it's got to be out in New York State is because they are basing this out of New York civil rights law. Why did I just forget the words there? Sections 50 and 51. This is a New York State law that this lawsuit is based on. It has to be within New York State because otherwise they cannot use this law.
And also there are rules of jurisdiction.
Yes.
John flubbed them and did not do them, did not calculate them accurately. But there are rules of jurisdiction. They are called long arm statutes when people live in different states. It's perfectly normal, happens all the time. And some of those rules are subject matter. There are certain courts that are very specific to certain things, such as criminal law, bankruptcy law, tax law. There are certain things that have subject matter jurisdiction. Then there's also personal jurisdiction, which simply means the court has the power to enforce the law on you. And that is usually divided by state and by county, where the majority of the incidents leading up to this lawsuit took place. It's usually one of the best ones that is relied on. It seems that is what John was trying to do, but failed because he did not file it in the county where the majority of the events took place. We have no idea why he filed it here. We have our theories, but John is dumb.
We'll probably never know the full answer to that question, but no. It is a fun one.
Everything's an enigma with that dickhead.
Flutter-64, $2. Thank you so much. Hello, Luigi and Cleavage. Well, hello, sir. Why is John so retarded? I don't know. I heard that he was an effing F word from somebody else, so it's hard to say.
Wait, go back to that one? What was it?
No, no, we're going to leave that there. We're going to put a pin in that also. Pony Power 2 for $5. That was a poorly worded question on my part, so I will repay you with Paber Benedict. I love it. Beautiful Pony Power 2. Incredibly, incredibly talented Pony Power 2. I cannot say enough good things about him. We are going to get into way more questions. We've put a pin into a couple of questions already. But Luigi and I have compiled a bunch of things that we want to get into, talking all about this. I think we're going to do a couple of questions, and then there's a very specific thing that I want you to talk about a little bit when it comes to what anti-SLAPP means.
Okay.
We might get into that with the questions, but if not, we'll kind of poke into that because I think that's going to be very interesting within this case. So let's go ahead and take a peek, if I can learn how to do anything whatsoever, at some questions. Yay, questions. So our first question comes from Herbert Arnold, and it says, why was there not one single exhibit attached to John's filing to substantiate any of the allegations he's alleging? Is this standard practice in New York filings, or are supporting exhibits normally attached?
What a fantastic question.
Great question. Absolutely wonderful. I have a few answers to this. I want to see if you are going to agree with me. You mind if I try to field this one first?
Can I just say this first?
Yes, please.
John is dumb. Go ahead,
Yes.
please.
Okay. That is one of the answers. That is certainly one of the answers. However, I will also say that you are correct that the plaintiff has the burden of proof in a case like this. They are responsible for presenting evidence to the court in order to convince the court of their claims. However, this complaint is what is called a pleading, not a motion. And at least in New York State, I'm not familiar with courts in other states, but at least in New York States, the courts don't usually expect or require any exhibits at the stage of the pleadings. So what the complaint is it is the point, the entire intention of the complaint is to give notice of the claims and the basic allegations. If John or Tabber or whoever the heck drafted this thing included exhibits at this stage, they might have boxed themselves into any sort of arguments. They also might have introduced evidence that ended up hurting them. However, as long as they have outlined everything within their complaint, they can bring those documents and evidence in within later motions or within discovery. Also, a lot of the time in New York State, courts prefer not to get all of those exhibits until they become necessary. A lot of the time, a case will not go contested at all. By contested, I mean the defendants will never file anything responding to the allegations. If that's the case, the courts don't want to be bogged down with 8,000 papers.
Nor would they care about them.
Nor would they care about them, because they are going to take the plaintiff's words with much more loftiness, I guess is kind of the explanation of that. So I think it is not entirely irregular to have a period of time where when the complaint is filed, you wouldn't see those exhibits. I find it bizarre that there were 0 exhibits.
Yeah.
I'm not surprised that there weren't a lot. Like, I usually when I see things exhibited, there will be like 1 or 2, and then they'll present the rest of the exhibits later after motions start getting filed. This has absolutely nothing, which is peculiar.
I agree with all that. It is very weird and really just goes down to exactly what we've said from the very beginning, is that this was just not a coherent thought in this lawsuit, and no substantiating evidence, no substantiating argument for the causes of action. I mean, I don't get it. But yeah, you're absolutely right. There should have been something to simply substantiate the claim that just said, hey, here's what I'm talking about, something. But no, he didn't do anything. So whatever.
Again, not entirely irregular at the complaint stage, since this is just a pleading. Now, I do have a question for you that I don't understand at all. I'm going to explain my understanding, and then you're going to tell me how incredibly, incredibly wrong I am. Maybe I'll hit the jackpot.
I haven't been wrong yet.
Well, so my understanding is that for a civil rights law is that the plaintiff has to prove their case based upon a preponderance of evidence, which means that they have to show that it is more likely than not that their claims are true. So John would have to show that it is more likely than not that he was harmed by Karl and Shuli using his image in order to prevent DabbleCon 2 and Dabble House. Am I correct so far?
You are correct. And there's obviously not a very clear line to draw in the sand as to what that necessarily means. And that's why you typically have a jury to make that determination, so that you have basically a miniature think tank to decide if they qualify for that terms and if they agree that the facts of the case satisfy those terms. But the way I like to think about it is that whereas in a criminal trial, or I guess it doesn't even necessarily have to be a trial, but for a criminal conviction, you have to prove beyond reasonable doubt. And what that typically means is, if you want to put it into percentages, and this is completely hypothetical and not intended to be meaningful in any way, it has to be somewhere between 95 and 100% certainty that this person is guilty. And again, that is completely hyperbolic. It's completely hypothetical. Go ahead.
I thought, and again, I might be entirely wrong about this. I thought that was more accurate for criminal cases. But
that's what I said.
Civil. Oh,
I said
I'm
criminal.
So sorry.
No.
Oh,
I said for a criminal conviction. For a criminal conviction,
yes.
yes, it has to be between 95 and 100%. Now,
for a
civil, it just doesn't necessarily need to be that. 95 to 100.
I bet it's 51.
But it's not exactly 51 either. It's just simply by, preponderance of the evidence,
Yes.
which just means more likely than not, but still with some certainty. So if I had to, again, completely hypothetical and hyperbolic, had to put it at something, you're at least 75% sure. And so that's where we are. It doesn't have to be with absolute certainty to say that John is entitled to anything. It just has to be more than average. How's that?
More than average. I love that. I think that's he's never been more than average in the past. So let's assume he will continue to not be more than average.
Yep.
Let's move on to our next question that Luigi and I have compiled here. So this one is from David the Cobra, and it asks, this lawsuit also doxes Karl and Shuli. Intentional. Now, we all talk about the word dox within our podcasting realm. Doxing in podcasting is not something that happens in lawsuits. Again, Luigi will correct me if I'm wrong. I'm going to go off on a majig here, and you can tell me if I don't have the words right. But when we're talking about doxing, what we're doing is within the podcasting realm, within the internet realm, is that we are releasing private information about people onto the internet that they wouldn't want to be shared. And this lawsuit does include both Karl and Shuli's addresses and phone numbers.
Mm-hmm.
This is now public record. The reason that lawsuits need to include that information, when people post that information on the internet about you and you don't want them to, that is doxing. Lawsuits are different because you need to be aware if you are being sued. The court needs to make sure that you have received proper notification of all of the legal proceedings. The defendant needs to be aware of everything. This is a fundamental right and requirement in order for due process to exist. And so I think that this question is really interesting, but I also would not define the inclusion of their addresses and their phone numbers as doxing. Rather, that is generally something that I see within New York State filed documents.
No,
I don't know if that's the case in other states and jurisdictions.
It's part of the procedure, but I'm curious if this person is saying that it was still, despite the fact doing it completely legally and procedurally accurate, if there was still the intended effect of getting Karl and Shuli's information out there. And I think yes. Yeah.
I could not agree with that more. And this has been a big question also within the current Ethan Klein lawsuit that is happening. So Ethan Klein is currently suing 3 creators over the use of his copyrighted material without making any commentary about that copyrighted material. And one of the things that he's currently seeking to do during that lawsuit is to determine the names of all of the moderators of certain snark subreddits. Now, why is he trying to do that? Well, one, he might want to sue them and they might be necessary parties to that action. But in addition to that, he's probably going to get a little bit of joy out of doxing those people. And I think, Luigi, you hit the nail on the head that is probably what is going on here, is that regardless of legal requirements, it probably felt very good for whoever got to type that up.
Sure.
Yeah.
And I think it was John.
Yeah. Next up, let's look at another question here. Luigi, this one is specifically for you, as I recall.
So Luigi, what? Nope,
Luigi,
he's my friend.
I have gotten asked this question an unbelievable amount of times. So please talk about who you are, who Hack Ride is, and where people can find you for a moment.
Oh, yeah, sure. Hack Ride is a character played by my friend Casey Day, and we do, Casey Day and I do several shows with the wonderful DJ Electra on Hack Ride Studios channel. We do Unboxing Eric on Sundays at 1 p.m. Eastern. Actually, you know what? No, our schedule has changed. We're going to now have shows on during football season. We're not going to do shows on Thursdays and Sundays. From now on, it's going to be Tuesdays and Wednesdays. But nope, that is Casey Day, Hack Ride Studios channel on YouTube, and I believe it's a Hack Ride Studios on X. So check him out. He's the best. He's my friend, my mentor. Love the guy.
Yes, we did need to clarify that,
Yes.
though. I felt it was very, very important to the questions of this lawsuit. Next up, we have another question. So, can they ask John if he ever mailed himself cocaine during discovery? I think that before we answer this question, we should talk about what discovery is.
Yeah, sure.
You want to field that?
Yeah, discovery is a phase of litigation in which there have been established national laws that say that you are allowed to ask the other party certain things. You are allowed to make certain statements. And then also you are allowed to make very customized conversational questions in order to gain facts about the case so that it can all be hammered out on both sides before the day of actual trial. I personally do not believe we are ever going to reach that phase in this case because it would have to come after several things. And I just don't see it happening. It would be long drawn out, maybe a year from now that would happen. I just don't see it happening. But the answer is during discovery, yes, you have an opportunity to ask within reason and within relevance anything you want and then argue that it is relevant to the case. Now, here's the funny thing is that if I'm wrong and we do actually go to discovery, I think that really nothing could potentially be off limits because of the fact that Karl and Shuli
John has already brought up tons of things that are off limits.
He's brought up tons of things that are off limits, but Karl and Shuli have made this business of doing a parody and satire of John based on the horrible things that he has done in his life. And therefore, in order to reinforce their stance on being a parody satire of John, they have to ask him some of the most embarrassing parts of his life. And I've said this over and over, and I feel like I'm going to stop saying it because I don't necessarily want him to hear it. This is going to go very bad for John, and it's going to get very embarrassing. I mean, there's going to be, if it were to get that far, which again, I don't think it is, they're going to ask John so many questions that he has avoided answering, that he doesn't want to answer, stuff about his family, stuff about his finances, then ask him to prove everything. Of course, they're going to have to argue. Not everything is going to be necessarily declared relevant, but they still get to ask.
Yeah. Well, we've mentioned a couple of times that John is dumb, and we have a very special guest here that I am seeing a chat from that I want to pull up because is very relevant to everything that we've been talking to and also to some stuff that's been going on in my life. We have Karl Heberger here who says they got his phone number wrong in the lawsuit, which is very unfortunate for him because that means whoever I have been texting is getting all the nudes I was trying to send to him. I don't know. Sorry, Karl. But that just goes to show how many mistakes there are in this lawsuit. So I do think that that is quite beautiful. Nobody tried to mess with Karl and Shuli. I love them, and I don't want anybody messing with them. So everybody shut up. Next up, we are going to be doing another question here. This one is another little bit of a silly one, but I think it's a relevant one. Will John ever stop embarrassing himself?
Thankfully, no.
Yes, I think that we can all agree that the answer to this is no. Did you listen to any of his stream the other day?
I tried. I couldn't get into it. I watched Tukey, and honestly, I love Tukey, but even he couldn't make it interesting. It was so incredibly awful and boring, and he just did nothing. He just sat there and talked about nonsense. It was terrible. It was obviously just a grab to just keep his channel monetized and just whatever. What an idiot.
He sure loves to give us little nuggets, doesn't he? Absolutely. Completely absurd. Yeah, he will never stop embarrassing himself. We will get to enjoy this for the rest of our lives, or at least the rest of his life.
And honestly, another thing, just really quick, going back to Discovery, is that even though I don't think it's going to go that far, I cannot emphasize enough how bad this is going to go for John. This is, even his worst enemies have yet to fully manifest in their imagination the ways that they can embarrass John during Discovery. This is going to go so bad. For a guy who has pride, for a guy who really tries to maintain a very specific image, it's not good. And this is an example of John embarrassing himself because he just is going to bring this on himself. It's another just absolute field of rakes that he's going to be stepping on.
It is true. And this, I think everybody can agree, is the biggest of the rakes. Although I was on Point Dabble Point earlier today, and we listened to some of John's crowd work during a recent stand-up gig. And I got to tell you, that might be more embarrassing than this lawsuit, which is saying something. So that was great. Absolutely great. I highly recommend everybody go check out Point Dabble Point. Next up, we have, what are the chances John would have to pay for all of the legal fees? This is a big question that we have gotten many, many times. And Luigi, I know that you have fielded this question a couple of times.
Yeah.
I think that... Oh, go ahead.
No, I was going to say, maybe we set this one aside for that specific thing that we are going to talk about later. I feel like it's going to cover a lot of these. Okay. But I mean, we can talk about it now if you want. It's just, I feel like it's going to be long.
Let me say a couple of quick things about
Sure.
this. I want to say that statutes 50 and 51, which again, that is the basis of this lawsuit, those statutes do not include any fee shifting provisions. So what the New York Court of Appeals has affirmed time and time again is that the principle that each party bears its own rights to legal fees. So win or lose, those fees are incidents of litigation. However, there are some exceptions to that, especially in the case of frivolous conduct. And in addition to that, I think that you are referring to something, Luigi, that we will probably be getting into a lot. So Luigi is going to talk about in a little while something that really could change how those attorneys' fees are working. So the statutes themselves do not have any of those fee shifting provisions, and New York State Court of Appeals has generally affirmed that everybody has to pay their own legal fees in cases like this. However, there is an exception to that
one
Luigi will
big
get into.
exception.
A huge exception, absolutely. I think we can tease what that is called, and then we will describe it in a little bit.
And maybe we hold that for episode 3.
Oh my God, no. I'm so excited to talk about it. That really is very interesting stuff. So
Okay.
I can't wait to talk about it.
Yes, it is the SLAPP statutes. And
Yes,
we'll get to it.
the Anti-SLAPP statute. And we will be talking about that. And that has also been talked about. I mentioned earlier things like the Ethan Klein lawsuit. That has been talked about in many, many, many cases. So it is really interesting. And Luigi is going to give us a huge breakdown on that. Before we get into more questions, we are going to take a peek at a few more super chats. So thank you guys so much for being here and hanging out with us and making us feel special about all of this stuff. I can't see that entire words. Sharky Waters for $1.99. Thank you so much. Who's dumber, SJ, Moobs, Kiki, or Gashley?
I always got to go, John. I've yet to see anyone demonstrate a lack of intelligence more than John.
I also am a firm believer that women are dumb in general, so I give them a little bit of a pass on the dumbness scale because they're inherently dumb. So it's SJ. It's SJ is the answer to that question.
Inherently dumb.
Yeah. Next up, we have another super sticker for $4.49 from Larry Appleton. Thank you so much. And we have Shane M coming in with $10. I know you are both biased as I am. You are still doing a great job of explaining the legal aspects of this case. Thank you so much. That is really, really appreciated. We're enjoying the heck out of this, so thank you for hanging out with us for it. John's Gimpy Halloween Hand for $2. What are the incentives to take cases pro bono? Publicity?
Well, that really depends. A lot of big law firms, larger law firms, not like his, I'm talking like where there's, several hundred lawyers, really make it a point to do pro bono work as part of promoting their own law firm. There's actually some law firms that have quotas to make of pro bono hours just for the sake of doing it as promotion for the law firm, and it's part of your employment contract. I've seen it a couple of times. It's not a lot.
Tax write-off?
It is a tax write-off for the law firm, absolutely. But when I mean incentive, I guess I'm immediately defaulting to publicity and what kind of public benefit you can get. But yeah, of course, it's a tax write-off because it is donated work. But there's so much promotion that can go into it if you have a cause, if your law firm's big enough and can use the promotion of doing it. Also, there are lawyers who are well off and just devote their lives to doing pro bono work just because it's a good thing to do. I knew a woman who was a wealthy estate planning attorney who found a niche of pro bono work that she really, really enjoyed doing. And that was to go to a nearby military base and she had a schedule of when there were returning troops. And she really enjoyed hanging out and advertising free divorces for the returning troops because she said that without fail, when soldiers would return home, they would find out that their spouse had cheated on them while they were gone.
She sounds like my kind of woman. I love the idea of a free divorce. Divorces are like my favorite thing to do next to getting married. Come on.
It was weird. And I remember thinking, God, what a niche. But she just said it's a real need. It's a real need because there are people who come home very unhappy and they don't know where to turn. They don't know what to do. And they are angry. And sometimes people wind up getting hurt. And she said, if you can just kind of quell the emotions, let them know you'll take care of everything. You can even usually do it pretty easily. You know what? At the end of the day, you feel like you're doing a good deed. And I was like, I'll take your word for it. That was odd. But anyway, there you go.
Next up, we have Happy Valley Wrecking Crew. Thank you so much for the $5. If Dummy says, they trashed my family. I can't do his voice. In his deposition.
They trashed my family.
Oh, you're worse at it than I am. Good God.
That's what I hear. I hear a goblin talking. Da, da, ba, ba.
If they said they trashed my family in his deposition or in the complaint, does that expose them to being disposed?
No, not at all. They're not parties to this.
Next up, we have Michael C. for $1.99. The lawsuit is John's second mistake, the first being nice.
I don't know what that means.
For $4.99. Can they ask John if he truly believes his kid has mental problems to prove that he was telling the truth on the tapes?
I guess you could, but there's probably going to be a real argument of relevance there because the actual content on the tapes is going to prove to not necessarily have any effect on the cause of action of right of publicity. They just want to know if they used them and if they profited them in an illegal way and didn't transform them or satirize them. So there's always worth asking, but you're probably going to get an argument of relevance and probably lose. But still, you have the opportunity to ask.
Club 102. I can't read what those words are.
Club 102, Resita's hottest gay bar.
Yeah. $4.99. Thank you so much. I hope John's goodwill is challenged by him having to talk about and provide documents from his cancer charity scam during discovery. Again, I think relevance would come up here, perhaps.
Yeah.
But it doesn't hurt for us all to have these wishful wish lists of what would happen in discovery. I like the idea of a wish list. Jay Wolfenstein for $2. Thank you so much. Can Karl cut his losses by firing Shuli from WATP? Listen, we all know that Shuli is the co-host of WATP and has no other podcasts of his own. We just don't know, I think he's going to have to. I think Shuli's done for here.
Cut his losses.
I think he's done.
Interesting. No, I doubt it.
No. John O'Reilly, thank you so much for the $4.99. Do you think the cause will be transferred to federal court based on diversity grounds? There may be fee shifting allowed there. Oh, so that's interesting.
That is interesting.
Do you have an answer to that?
Yeah. Go ahead.
No, I don't know that I have a thought.
Oh, you said you do.
No.
I don't think it will be transferred on diversity grounds. I think this is a pretty clear-cut issue of there is a very specific and correct jurisdiction in which it should have been filed. It just failed to be. So, my opinion.
Yeah. Well, there's many failures here. Many failures here. Next, we have Jay Wolfenstein again for $5. Thank you so much. I heard Luigi's SJ impression. I want my super chat money back. Thank you. I did better than somebody on an impression once.
All right.
I'm just going to tell you right now, producer Chris has about 1,000 hilarious audio clips of me trying to do Stuttering John impressions from when I was doing the net news over on WATP, and it is really embarrassing.
No one is ever going to outdo Chris's impression. His is the
amazing.
absolute
He's
top.
Amazing.
Yes.
He's amazing. Absolutely amazing. I also want to say absolutely right now, guys, we are going to be talking about if Karl and Shuli might be able to recoup their legal fees, but I want to tell everybody and remind everybody, support the heck out of them right now. Not
Please.
just monetarily. Support the heck out of them in your chats. Support the heck out of them with liking, with subscribing to them if you aren't already. I suspect that if you are watching right now, you have already subscribed to them. I love these guys so much, and no matter if this lawsuit ends up being good for them professionally, it is not fun to get sued. They are handling this incredibly well. I would not want to be in either of their positions, and I love these guys. Go make sure that you are supporting Who Are These Podcasts. Make sure that you are supporting the Shuli Network. Everything that you can do. Turn on the videos. Leave the advertisements playing. A lot of people don't realize if you leave ads playing, that really impacts what we make money off of on YouTube. So if you don't have money to be able to give them in super chats and super tips, you don't have to do that. Leave the ads playing. Leave the likes. Leave comments. Go support the heck out of those guys because they deserve it right now so much. I cannot say enough about how much they deserve that.
Agreed.
Yes.
Please go support them.
Yes, please. I love these guys, and I don't want anything bad to ever happen to them. And even though I don't necessarily think that this is a long-term bad thing, I imagine there are some sleepless nights over it. I cannot imagine that it is all sunshine and daisies for those guys right now. We're going to get into some more questions here. We have another one coming from Troll Hunter over here. This question says, that's not the question that I have as the next question. Maybe it is. Oh, no, it is. Okay. Were the tapes illegally recorded if John was in California? Nope. I am reading the wrong question. Am I reading the right question? My glasses are not on, so I'm reading off of something else. No, I'm reading the right question. Yes.
Okay.
Were the tapes illegally recorded if John was in California or Florida and Kate was in New York? Great question, because California and Florida are two-party consent states, but New York is a one-party consent state.
Yeah, and it's honestly not always a clear answer with this sort of stuff when there are conflicting laws, but I do not think they were illegally recorded. For a couple of reasons. One being that the origination spot of the recording was a one-party state. Then also you throw on top of it that John specifically says, I know you're recording me. And there's just a lot of factors to take into it that no, they weren't. But also completely irrelevant to a right of publicity claim. They have no bearing whatsoever, no impact, no relevance. And the fact that he wrote that in there was just a weird tangent that he went on in his complaint, because the court's not going to care about the legality. But I would ultimately, if I were...
Not only is the court not going to care about if they are illegal or not, because that has nothing to do with this lawsuit, not only is that irrelevant, but in addition to that, to refer to those calls as illegal is not correct, because it has not been ruled upon by a court. It has not been ruled upon by a court. Therefore, you cannot call those calls illegal. We can make conjecture right now, and Luigi better than I can, because he's an attorney and I am not. We can make conjecture about if we believe that those calls were illegal or not. However, until a judge makes a ruling on that, there is no determination. Now, I will say, to counter what Luigi just said, I do think that there could potentially be a violation of the California and Florida laws, because those are both the two-party consent states. Now, violations can result in criminal penalties and liability in civil court. So if cases were to be brought, it is possible that these might have determined, these tapes might be determined to be illegal. They have not yet. However, what is very interesting, and this was kind of brought up in one of our previous questions in the super chats here, is federal laws generally only require one-party consent. And because these were going across different lines, chances are this case would be a federal case. The courts have not definitively ruled that federal overrides state law for these interstate recordings, but in general, that is what happens. And moreover, this lawsuit, Stuttering John versus Karl and Shuli, is in New York, and it is not the crux of the issue that is at hand here.
No, not at all. And it's really baffling why he would put that in there. But also, when you throw in the fact that he's making a conclusion of law, you're absolutely right about saying that it's illegal. There's been no determination of the legality of it. Then saying that he actually reported it to the FBI and they chose not to pursue it, that really would usually, to a normal, reasonable person, suggest that he now knows that it is not illegal, and therefore determining that it is in fact illegal in this complaint, some might consider perjury.
Interesting. Who even knows?
Who knows?
Knows. All right, we got another question here. This is going to be another big one, but I think it's a really good question. And Luigi, I think I'm going to have you kind of take a little bit of the lead on this one as well, because you will know a little bit more about this. However, I will interject and talk a little bit about New York State specifically. So the question is, how about a roadmap with estimated dates for how this plays out? What are the odds that SJ is deposed? If you would explain the legal next steps and the probable legal next steps, what I will do is I will talk to you about how long those steps usually take within New York State courts, because I am very familiar with those.
Sure. Since Shuli and Karl have been served with the lawsuit, they have 30 days to make a response, which simply means that you understand that you are in fact being sued, and that you intend to fight it. And then also you will file your motion to dismiss, which basically says, I know about this lawsuit, but judge, this person did not satisfy all the requirements to make a valid, legitimate lawsuit. I believe that while that is usually not really the best of odds to win a motion to dismiss, I believe this might be different, because there are so many egregious mistakes and failures to it. I believe that there is at least a 51% chance that they could get this all thrown out with a motion to dismiss. So that is normally going to happen within the next, let's just say, maybe 30 to 40 days. And then after that, if the lawsuit survives the motion to dismiss, then all of the other things such as discovery, depositions, all that will get planned out. I just don't see it happening. I just don't. That's me, but if it was to happen, we're probably talking somewhere around 6 to 8 months away when that phase probably starts. And a trial, again, I don't see it happening, but if there was a trial, we're going to say at least a year and a half away. That's my thoughts, but you please absolutely tell me where I'm wrong.
Well, I will add one thing in here, which is that I just actually pulled the case up to see if there were any newly filed documents. So you are completely correct. Karl and Shuli have been served. The next thing that we can expect to see within the court records themselves are going to be the filed service affidavits. So that is going to include information about when and how both Karl and Shuli were served. In addition to that, though, there was something filed within this case that was not filed within some other lawsuits that we've recently talked about, which was the request for judicial intervention. And I have harped on those a whole bunch. In this case, the request for judicial intervention is asking the court to set up a preliminary conference relating to this. So if the court does, in fact, set up a preliminary conference, I would guess that that would be set up for someplace within the next 3-ish months. Typically, those conferences get run concurrently with the time during which Karl and Shuli have to either answer or file a motion to dismiss or respond to the allegations in the complaint. So I would guess that that conference will get scheduled relatively soon, but it will probably get scheduled for about 3 months out because that's generally what I'm seeing with New York County at this point. After we kind of move forward into the court trying to look at the motions and make decisions on the motions, again, I think a lot of the time that courts will push these things off and they'll push them down the line because they don't want to make a decision. So I think that realistically, we're probably looking at a little bit longer of time before this really starts to get seen by the courts. I would guess probably 6 to 9 months before we get any sort of responses from the court, even if we get responses from Karl and Shuli far before that, which I do agree will happen within the next 30-ish days.
Yep.
And a very interesting question. I will say, even though I know a fair amount about the New York County courts, I really don't know how they're going to take this case. This case is very different than what I have seen in the past. Our next question here is, neither Karl nor Shuli recorded the tapes. Instead, they received them from a third party not named in the lawsuit. Doesn't that immediately exonerate them from culpability? Now, we've already kind of discussed this. This is asking, how much do the tapes play a factor into this lawsuit? And the answer to that is almost nothing at all.
Yeah.
The lawsuit is specifically about profiteering off of John's likeness based on the privacy publicity statutes of 5051 of New York civil rights law. I do think that the reason that this question is so interesting, though, is because it again asks the question of, why was Kate not named in this lawsuit?
We could go on. We could speculate about that for hours.
I mean, I think that the short answer to that question, which again, you and I kind of did talk about in our previous episode, but I think the short answer to that question is John is in love with Kate, right?
Yeah.
Like,
yeah.
he would do tapes volume 3 if he had the opportunity to. He is so smitten. He is so unwilling to admit that she did anything wrong that he will not harm her in any way. And so probably in order for him to agree to move forward with this lawsuit, which I think he was probably prompted to do, he probably said, the only thing I'm not willing to do is sue Kate. I'm unwilling to put her name in a lawsuit.
I still think I can have sex with her.
I am totally going to score. I'm totally gonna score.
And I've said this before, and I'm just gonna keep saying it again, that it is like putting together a puzzle where none of the pieces fit. There's just so many things about this that just do not make any sense at all. It's weird. And yeah, the tapes thing is irrelevant to a right of publicity cause of action, which is what is exactly what John is suing for specifically. It has nothing to do with with recorded tapes. It is whether or not his voice and likeness was used for something. Whether or not it was illegally recorded, that's for a criminal court to decide. And honestly, to some extent, it's already been decided when the FBI chose not to pursue anything because they didn't see anything illegal being done. None of this makes any sense, and it's incoherent. It's absolute nonsense, really. That's all I can really say.
Next up, oh, hang on, I lied. Not next up. I got to remove things from the studio. I know how to do StreamYard. I'm very professional over here. Doing really great. All right, next up we have another question, and now I lost where I was at. Here we go. Very much anticipation for a great question here. This one says, any updates on your relationship with Purple Boy? This is specifically for me, and I'm going to say we're completely in love. We were talking about Stuttering Johnson earlier. You can go see Purple Boy on my Patreon as well. But yes, we are totally still in love.
Got it.
And on that note, I think that we will go back into some super chats, and then we'll get back into more questions about this lovely, lovely lawsuit here. Our lovely Lolsuit. Shaka John for $4.99. Thank you so much. What are the odds that John will simply back out of this lawsuit? Would he even be able to at this point?
My opinion is that's exactly how it's going to end. After that motion to dismiss gets filed and there has to be more hours and more effort put into it, I see it just drifting away. And John, I don't see Benedict being willing to continue to pay for it. I don't see John having the fortitude to stick with it and see that it gets done, nor the resources to do it. So I think that's exactly how it's going to end.
Now, I will say, would he, the question also, would he be able to at this point? Yes, you can absolutely withdraw a lawsuit at any point in time. What you would do at that point is something that is called voluntarily discontinue the lawsuit. So you would say, I am withdrawing this from the court. I'm absolutely done with it. And I do agree. I think that it is more than likely. It's either going to get voluntarily discontinued after that motion to dismiss presumably gets filed, or it'll die on the vine. We'll see what happens. Next up, we have the absolutely incredible, truly, truly wonderful, amazing, Weird Medicine, Dr. Steve with $20. Thank you so much, Dr. Steve. You are a saint and a wonder, and you're asking so many questions here, but luckily they are not in Hebrew, so I can read them. Could John win, but be awarded only $1 for damage to his reputation? I think the answer to that is, could it happen? Anything could happen. The likeliness, I would say, very, very low. Would you agree, Luigi?
Absolutely. And also, what else damage could he get to his reputation?
Yeah. If so, would there be any long-term effects to Karl and Shuli? I think that the biggest long-term effect to Karl and Shuli is that if John wins, they're going to be the laughingstocks of everybody, right? I hate to say that about my buds, but I think that would be the negative effect. I think we would all rally behind them because we love them, but I don't think that there's any long-term negative effects other than people will laugh at them.
Then having John go, ah, ha, 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 ha. Yeah.
But let's be honest, we all make fun of them already. They're both idiots already. All this is going to do is give people more fodder to make fun of them. So maybe it's not even that bad of an effect.
Yeah, but it'll probably bring them more super chats.
Well, you never know. Yeah. He also adds, I saw a movie once where this happened, which is where all of my legal knowledge comes from. I don't know what movie that is. I want to know what movie that is. Why can't I think of anything?
I can't either. I don't know where that ever happened in a movie.
Dr. Steve has way better film knowledge than I have, and I owe Dr. Steve a message back because we need to talk about Peter Weir, sir, so I'm behind the times, but I'll be back in touch with you soon about that. Club 102, we have another $4.99. Thank you so much. What are some examples of embarrassing questions that could potentially be asked or documentation provided during discovery that are relevant? I do love that cocaine question.
That is, I mean, that's a sky's the limit question. I mean, there's no way to put a cap on that. But
Are
yeah,
some of the most embarrassing things that John has done? I think just being a drunk idiot all the time.
being accused of SA, shitting in sheets.
Yep.
Because these are the things that were specifically mentioned
Cat
and talked
shit
about on
everywhere.
the show. Cat shit, yes. Being a deadbeat dad, there being a court judgment against him for being a deadbeat dad, leaving a child who was, I believe, 9 years old at home so that he could go get drunk at a bar, not telling his son he loved him because the kid had cat hair on him. I mean, again, sky's the limit. But these were all things that were specifically talked about on the air, and therefore they're open to being discussed at trial. So,
They sure are. They sure are. I will say we have an interesting chat here from Jared. John with $600,000 would be legitimately entertaining. I don't disagree with that at all. I don't want to see it, but
I do.
I
can't see anything that makes him entertaining.
Let's not root for the adversary here. But I would like to see that. Smooth 199. Thank you so very much. Can I see Luigi's diploma? A class ring will do.
He's seen it. It was my cock ring. Smooth.
TV's
Thank you
Well
for being here.
Heron, our wonderful TV's Well Heron. Absolutely great. Wonderful article that you wrote. Y'all are crushing it. Thank you so very much.
Thank you, Mr. Well Heron.
Dave Doors, $5. Thank you so much. SH and KH should settle and offer 2 12-packs of Busch Light and 1 12-gallon Poland Spring. ST will take the offer. It's true that he has been doing some very interesting beer math, again, that we discussed quite a bit on Point Dabble Point earlier today. Go check that out.
Sad.
His
Sad.
His new theory is that if he just drinks water at the same time that he's drinking beer and then it mixes up in his belly, that he is diluting the beer with the water.
And therefore, it's
And
just
there
as
is
good as only
healthy.
water.
Yeah.
Yeah.
It's so healthy. Oh my God. I know when I eat Taco Bell, I also drink Baja Blast, and that's how I stay so trim. Duh. It's great. It's so logical. Jared coming in with $5. Thank you so much. Who is this stunning beauty? Oh, and Lucy is here. I have never sued anyone. How much could Stuttering John even feasibly be paying at this point? If he is paying money, I would guess that he had between $5,000 and $10,000 retainer.
He's not. He's
If he was, would you agree that
Yeah.
probably between $5,000 and $10,000 for the retainer?
Yeah.
So that would be money that would be used. The way that retainers work is that you have to give an attorney a certain amount of money, whatever amount of money that you guys agree upon, in order to be able to have attorney-client privilege with that attorney. And what they do with that retainer money is that as they are working on the case, they pull funds from that money in order to be able to pay themselves. So, for example, if they are going to charge, let's say, $500 in order to draft a certain document, they would take that out of the retainer. At some point, the retainer almost certainly has to get replenished. So most of the time that would happen. My guess, though, would be that his retainer is $10,000 if one exists, which again I think we all don't exist. We all exist.
On my show on Friday, I went through the full history of John's lawyers,
Yes.
and I don't have any reason to believe that this situation is any different than the same scenario that has played out at least 5 times before this.
Yeah.
And that is that John doesn't pay for lawyers.
Yes.
He uses favors and connections and pro bono hours to get his work done, and constantly fails and has never successfully done anything legally since the Dabbleverse was created.
Yeah.
And I don't have any reason to think this is any different. And so that is why I believe that once the bills start racking up, Benedict is out and is just going to say, I can't devote these resources to this, John. And then he's going to be fucked.
Yeah, absolutely. And next up, we have Jack Sampson in for $5. Kaylee, would you consider going on the Pretty Antisocial podcast? I mentioned it to the ladies, and they seemed willing. Hey, Laughin' Luigi.
What's up, Jack Sampson?
Yes, I
they're
would love
they're
to
great.
join them. They're amazing. They're so incredibly talented. They know far more than I could ever possibly know about Aaron. So whenever I'm listening to them, I'm always just gobstopped by how incredible they are. So I would be honored to do that.
They are great.
Yes, absolutely great. All right, let's get into some more questions here. Let me organize us a little bit. I don't even know where we were at. Where were we at? There's so many questions, and they've all been so good. Everybody is asking really, really interesting questions about this lawsuit. All right, we have this one here. This question is, if/when the lawsuit is dismissed, can Karl and Shuli sue, or would it be countersue for harassment? Further, can they sue Stuttering John for legal costs for having to spend money on defending against a frivolous lawsuit? Now, we have been asked this question repeatedly, or similar questions to this. I want to answer here, and then Luigi, I think it's a great time for us to get into the anti-SLAPP stuff. So I'm going to answer part of this question, and then I'm going to have you field what anti-SLAPP is, explain all of that. This question starts out by asking, could they sue or countersue for harassment? I don't know that I would call this a harassment case. That being said, that does not mean that they cannot countersue or file a cross motion to dismiss or any of those other things. Again, people can sue for anything. Do I think that there is enough here for them to be able to win on that? Not necessarily. But again, I think what we really all are asking when we're asking questions like this is, what about the legal costs? If Karl and Shuli prevail, will they be able to recoup those costs from Stuttering John? Will they be able to get Stuttering John to pay off their attorneys? So Luigi, explain to us what anti-SLAPP is in order for us to understand that question.
So SLAPP lawsuits are a determination category of lawsuits that were specifically created to be identified in the litigation process as having intentions beyond what are necessarily just the legal ramifications. Now, I know that's going to sound weird, but let me clarify. There are lawsuits that are people trying to actually recover a reward or recover a payment because they've been wronged and legally wronged, and they're entitled to it. But a SLAPP lawsuit is a specific kind of lawsuit that lawmakers decided to categorize for a lawsuit that doesn't necessarily have that intention. That if, based on the circumstances and based on the context, it is determined that this lawsuit was actually just simply intended to censor or silence a critic because they just don't like it, and it is an attempt to basically put a financial hardship in front of them, then there are ramifications for that. Yes. Specifically, New York has a very, very strict anti-SLAPP lawsuit. And so, I'm sorry, SLAPP actually stands for Strategic Lawsuit Against Public Participation. So what that means is that when you file a lawsuit and you make your argument, you say, I am entitled to X because the law entitles me to X, or because maybe I lost X amount of money and I want to recover what I lost. But then there are sometimes lawsuits that are just filed with the intention of trying to stop someone from doing something that they are perfectly entitled to do. And that's what this is intended to stop, is that if someone gets sued, and when they respond to that lawsuit, they basically are, just for hypothetical and hyperbolic explanation, they're ringing a bell. And they're ringing the bell and saying, I believe that this falls within the category of a SLAPP lawsuit. Then a whole new set of standards and rules apply if it is later determined that it is in fact only done for a malicious purpose to try to silence a critic or censor, intimidate, whatever. without an actual legal basis. And therefore, if at the end of the lawsuit, it is determined that the plaintiff filed it for those specific reasons, the defendants actually get to recover all of their attorney's fees from that plaintiff.
Absolutely. Absolutely. Perfectly said. And we actually have a follow-up question here in the super chats relating to this. June Cleavers Beaver for $2 Canadian. Thank you so much. Can they file a civil suit for their attorney fees? So you want to add on to that. I think that you explained it perfectly with how anti-SLAPP could potentially factor into this case. But this is also an interesting question that is a little bit nuanced of a difference.
Sure, but New York has their own anti-SLAPP lawsuits that are stricter than most, or at least I should say that qualify for SLAPP more broadly than most. So the anti-SLAPP is actually pretty new. It's only about 3 years old, I believe. And there are cases here that have been defined or declared to be SLAPP. There have been cases that have been declared to be SLAPP cases very liberally, very, very liberally. And essentially, if it can be determined that you are attempting to violate someone else's First Amendment rights to say what they want, parody what they want, transform content, then you can be punished for filing that lawsuit. And
Absolutely.
I believe that this falls within the New York anti-SLAPP lawsuits perfectly.
Yes. So you think that if this were your legal opinion, if this were your case, if you were the attorney who is being hired to take care of this case, you would be leaning towards that as opposed to filing a separate civil lawsuit relating to those legal fees.
Correct.
That is the thing that makes sense within the context of this case, and that is what the case law seems to kind of lean towards, right?
I agree. And yes, exactly. That's what I feel. And like when you file that motion to dismiss, I believe that is the time procedurally to declare that you, as the defendant, that you believe that this is a anti-SLAPP case and that it should be that the lawsuit should proceed as if it was, meaning that at the end, if it's declared that this did fall into the category of only trying to intimidate the defendants, that John could be fucked.
Yeah.
Yep.
All right. Next up, we have another really interesting questions. Oh, this one wasn't the one that I was going to do, but we're going to do it anyway. We have, wouldn't you have to prove that the recordings were illegal in the first place, which would mean suing Kate first? And can you sue someone for being a dumb fuck? I think that we've answered the first part of this question. I'm of the position you can sue anybody for anything. I just think the court would throw you out if your lawsuit was you dumb fuck. But I do think that is a funny question. And we've already kind of addressed the tapes, so we will move along from that one into this next question. What have I done with my questions? I'm not doing great on these. Let me go back and again, this is another one relating to the Kate Meany tapes, etc. This one is the one I'm trying to find. All right, another question here from Troll Hunter. How does this differ from the Hogan versus Gawker lawsuit in which Hogan was successful?
I did answer this one directly, but the issue is that Hogan sued under different causes of action in a different jurisdiction. And a lot of people, and there have been documentaries made about it, a lot of lawmakers believe that that particular case was incorrectly adjudicated. Like that, a lot of people don't believe that that's how that case should have ended. I, for one, agree. It shouldn't have. But regardless, the issue was also for newsworthiness, meaning that it was played without, like we specifically talked about with the greeting card case.
Yes.
It was just simply played for the sake of playing it. There was no transformation. There was no parody. There was no satire. And so that is the biggest issue, was that they were just playing it just to play it. And again, he sued under different causes of action. But ultimately what it came down to was parody and satire. There was none of that involved, whereas in this particular case, the whole thing is about goofing on John.
Yes, absolutely. Absolutely. All right, we are going to move into a couple of really, really interesting questions. I think perhaps some of the best questions that we have gotten so far relating to this case. I'm going to kind of skip around a little bit in our questions because I'm just so excited for these ones. So this one asks, oh, no, I did bad. Let me do the things that I'm really good at doing over here without removing us from wherever we are. Everything is great. Okay. Hang on. And this one, yeah, okay. So this question asks, could someone pretending to be this Benedict/Duct have filed this lawsuit? Is there such a thing as a spoofed filing? Now, in New York, cases are generally e-filed, and that was the case with this particular lawsuit. And when you are filing something through that court system, you are affirming that you are that attorney or that you work for that attorney firm. So if somebody were to do that, it would be very, very bad, and I believe very, very illegal, and very, very much a reason for somebody to lose their ability to practice law in New York State.
Yeah, and to say that it doesn't happen, I don't ever like to say anything with 100% certainty. I'm sure there's some way to do it, but it's very, very unlikely because of the fact that you're constantly getting updates from the court. You're constantly getting notifications and phone calls from the court. So it's not something that you can really rely on as actually occurring in real life. But that being said, I have made it very clear that I don't believe Benedict wrote that. I believe John wrote it, and that's why the name was misspelled, because John doesn't understand English and can't read. But hey, because I find it so hard to believe that a lawyer would write that.
I know that you are suspecting John here. I don't think that John is intelligent enough to write this. I think that this falls into a weird middle area of between a attorney and John. I think that it is higher intelligence than John. But I will say, and I have insinuated this, and I will continue insinuating it, I think that it is possible that somebody else, another attorney who used to be a part of the Dabbleverse, I think it's entirely possible that he was involved in some way in the drafting of this summons and complaint. And if that were to be the case, he might want to, I don't know, fuck with John a little bit because he thinks it's funny. And so I think it might be more likely that he is involved in this than it is that John is. Now, I could be totally wrong about that. We could both be totally wrong. Who the heck even knows?
Yeah, we'll never know.
We'll never know.
Yeah, we'll never know for certain. But if this was written by a lawyer, it was a lawyer who didn't care about John. How's that?
Yes.
Yeah, that's a middle ground there, right? Yeah.
I could not agree with that more. Now, I have saved what I think is my favorite question for last here. I know that we have some more questions in the chats here, so we're not quite going to be done, but this is one of my all-time favorite questions that we've been asked. I know that both Luigi and I are really interested in this one. So this question comes to us from Sir James Levin. If one argued that the statute of limitations has already passed because the date of harm should be the first day that they started selling tickets or advertising DabbleCon 2 using John's image, how good would that be? Now, I want to back this up for a quick second.
Sure.
Because I want to explain the statute of limitations so that everybody understands why this question is so incredibly good. This is the best question that we have received. This is
a good one.
Questions.
This is a good one.
This question is incredible. So I'm going to explain to you what the statute of limitations is. I'm going to explain to you my background within the statute of limitations, and then we're going to explain why this question rules. The statute of limitations in New York State for this type of civil practice, of civil rights law is 1 year. That means that John had 1 year in order to start a lawsuit based upon this cause of action. Now, the question is, when does that time clock start ticking? And Luigi and I, when we both started talking about this last week, we were both saying, well, the clock started ticking on the day that DabbleCon 2 was held, which would have been August 16th, which would have meant that John had filed this, August 16th of 2025. Of 2024.
2024, yeah.
That would have meant that John filed just under that 1 year mark, which would have given him just barely enough time in order to be within that statute of limitations. However, the statute of limitations clock starting to tick is heavily debated. What the statute of limitations says is it says that you have a certain amount of time in order to commence a lawsuit, in order to start a lawsuit. And the point of that is so that you don't lose track of evidence, so that people who are involved and might be witnesses don't die. For example, if Luigi and I get into a car crash right now, it is really easy to figure out when that statute of limitations clock starts ticking because it's the day that we got into the car crash.
Yep.
However,
the day the injury occurred. Let's say that. Yeah.
It is much more complicated in other types of law. In particular, I am familiar with contract law in New York State. And in contract law, it can be really complicated to determine when that statute of limitations clock starts ticking. Does it start ticking on the day that the contract was signed? Does it start ticking on the day that the contract was breached? Where is it? When is that going to change around? And that is what this question is asking. This question is asking, when did the statute of limitations clock start ticking? And they are postulating that maybe the statute of limitations clock starts ticking on the day that Karl and Shuli started advertising these events, which would have been before August 7th, which is the date that this before August 7th of 2024, which would be more than 1 year since this lawsuit would have been filed, which would mean that John's lawsuit is outside of the statute of limitations and could be dismissed on those grounds.
Completely void. And to piggyback on what you're saying, while a lot of people will say that it was when it happened, his argument is that people made money off of him. Yes. So wouldn't it make more sense that the statute of limitation starts ticking when they make that first dollar off of him, according to John's argument, which was months before DabbleCon 2, which would mean John is potentially 2 to 3 months late in filing this lawsuit.
It is.
Boom.
This is a really, really incredibly clever question, and I can't say enough good things about this question. I think that this is cracking the case, and this goes to show we have so many incredible dabblers in our universe. We have so many incredibly smart people. We have so many incredibly talented people, and it is so great to see everybody kind of coming together to ask questions, to try to figure out what's going on, to say what is happening. And I think, Luigi, I can speak for both of us when I say we are honored to be able to get to talk about that with all of you, because that is genius.
We are glad that our hatred of John brought us all together.
Yes, it's amazing. It's absolutely amazing. So I think this is really great. Now, the reason that I said that this interests me so much is because I study statute of limitations all the time, and one of the first things that I looked at when this lawsuit got filed was, what was the statute of limitations? It's possibly blown. I didn't even see that. It's great.
His entire argument is about them making the money, and if he is in fact, as his complaint states, all based on him and every single dollar was based on him, then you got to accept the statute of limitations as being told when they collected the first dollar. Fuck you, John.
Yes. Yeah. Oh, absolutely. And again, what happens when the statute of limitations expired? It means that you cannot have a lawsuit. So the court can dismiss it on this. Now, this is a waivable defense. Statute of limitations is a waivable defense. And what that means is that if Karl and Shuli don't bring this up in their cross motion, in their answer, in whatever they end up filing next, that it could be waived. But I think it's viable, and I suspect that their attorney will be looking at that.
And what that means by waived means they would say, nope, fuck it, we want to keep fighting this actively. No one's going to do that. So, I do want to point out there is someone in our chat who was the person to first identify the cushions, and I'm not sure if she's being sincere, but she seems like she was a little worried that she was going to be a named party in this. Don't worry about it. You were not going to be a named party. Don't worry.
I still disagree that everybody was not named. That should have been. Again,
No.
Named.
I get it. I get what you're saying, but I'm just saying that I don't think for a second that as a practical matter, she was going to be named.
I think you are entirely safe here.
Oh, she's saying she was joking. Safe. Okay, all right. I wasn't sure.
Entirely safe. All right, let's go ahead. We're going to read a couple more super chats. Luigi, while we are doing that, I want you to think about if there's any other points that you want to discuss. While we were reviewing all of this and looking at this, I went and looked at the court's website to see if any new documentation has been filed. As of today, it has not, but Luigi and I will certainly be coming back to talk to you guys more as more and more documents get filed. We are really enjoying being able to talk about this, and we are loving doing that with you. So I'm going to read through these super chats. Luigi is going to figure out if we have some additional things to add before our next episode on this stuff.
Before you read that, though, is next Monday Edge Files?
That is a great point. If you're enjoying Luigi and I talking all about this stuff, you can join Luigi, myself, and Trucker Andy from All Apologies podcast next Monday at a time that we have not determined, but probably someplace between 7 and 8 p.m. Eastern time. We will post it on our social medias. We will be doing another episode of Edge Files. Edge Files, of course, is our wonderful show where we are living on the edge is how I want to describe it right now. But this week, we will be talking all about elective amputees, people who choose to cut off their own limbs even though they are perfectly healthy and allegedly mentally stable. So we are going to be looking at that this week, which is going to be very fun.
Skeptical Robot, Luigi Greenberg on YouTube.
Yes, absolutely. And go check out Luigi's episode from this past Friday. I cannot wait to check that out myself.
Yeah, we had Will Heron on and Spurgsnake, and Will Heron and I agreed we were going to talk a little bit about John before we got into the subject matter. And I went on a rant that I don't even think Will was expecting. I got very passionate, and I went through a full detailed history of John's legal representation. Folks, you might not know this, but yes, I'm a guy who plays a little bit behind the scenes, and I was behind the scenes before I ever had shows. So I do know quite a bit of history of the Dabbleverse and what was going on behind the scenes, and I just unleashed it because I started to get angry. I started to get upset about it. And I was like, fuck this guy. Let me tell you what's been going on. And so I went into, here is when John claimed to be his own lawyer using his own X account, claiming to be Vincent and Bessie and sent a cease and desist. This is the time that he hired a lawyer from a Legal Shield referral program. And obviously, like every other lawyer he hires, the lawyer couldn't have given a shit about John and sent out a cease and desist to a person in Alabama that only referenced California law. And basically, we just had to laugh at it. I told Shuli, call this guy up and ask him, why would this apply to me? He did, and the lawyer got pissed off at Shuli and said, the guy just wants you to leave him alone. Will you just leave him alone? And just, this is John. This is John. And I don't see this as being any different at all. So, yeah. All right. Again,
I think that's a great
I'm
point.
getting angry again.
That's a great. No, you deservedly so. John's Gimpy Halloween hand, $2. Thank you so much again. The way Kaylee says amazing is hilarious. I don't know how I say it, but I believe you, and I hope to see you in Detroit. We will be in Detroit for Who Are These Podcasts? That is already sold out, but if you want to come and hang out with me and the rest of the Who Are These Podcast gang, you can absolutely come and join us at Chrissy Mayer's Content Hotel. You can find tickets for that at WATPlive.com. That is going to be, I will be there on September 5th, but it is a whole long weekend of tons and tons of fun. Karl will be there, Adam Bush will be there, producer Chris will be there, Anthony Cumia will be there, and of course, the rest of the gang. Karl might get punched in the face. Maybe there can be 2 lawsuits all at the same time. I would really love that, so don't forget to get tickets for that. Dave Doors for $2. Thank you so much. What if they show SJ strikes? What if they show that SJ strikes on their channels?
It's irrelevant. I don't know if it's relevant,
but
yeah.
it would be interesting. And again, we can kind of. No,
go ahead. I'm sorry. No, I was going to say we haven't mentioned this in this episode, but we mentioned it a lot last episode. Which personally, I think there's a way in the motion to dismiss to specifically cite all of the reasons that this fails as being valid in any way. And one of the first things that I think should be mentioned is citing to one specific case. That case being Melendez versus SiriusXM 2022 New York Second Court of Appeals. I believe that he should be cited against himself to show his efforts in trying to make this work when it was thrown out with prejudice. Just want to throw that out
It's
there.
just a funny concept also. In addition to that, I love it. I love it so much.
I can't imagine a better knife twist.
Craig New York 77 for $4.99. Thank you so much. Any judge knows if SJ wins, everyone will start suing him, or everyone will start suing everyone. Listen, I can't believe that he filed a single lawsuit. Nevertheless, that he would file another one, but you never know. You never know. Craig New York 77 for another $1.99. Thank you so much. Sent a few questions to Once Over DM. I will make sure that we get to those the next time that we are up and doing this again. I am sure that we are going to be discussing stuff again soon on this. I don't think that Luigi and I can help it. We're having way too much fun talking about the lawsuit. I think it's
agreed.
It's kind of like the perfect intersection of both of our careers, right? So like for me, I keep saying it's the perfect intersection of my career. My day job is at a law firm, and then my night job is podcasting, and now I get to do both of those things, and that's really wonderful for me. And Dabbleverse, Jesus Christ, oh my God, who could have ever possibly imagined?
If there was like a Venn diagram of important things in my life, I really am ashamed at how much Dabbleverse is growing.
Yes.
Yeah.
Well, I feel like I'm right in the middle of all of those things right now, which is beautiful. Club 102 for another $4.99. Thank you so very much. We all know that SJ doesn't have a pot to piss in. So how would Karl and Shuli go about getting reimbursed if they could have a successful SLAPP ruling?
By being a little evil and saying, where's my money? Where's my money? Shouldn't you be getting the money? How about the money? Where's the money? That's how.
Yep. And in addition to that, if he doesn't have any money, I don't know exactly how it works, but I think that you can do garnishments if he doesn't
file
have any
a lien
coming in. Yes, he could file a lien, which would then put a judgment against him. And would Karl and Shuli ever actually recoup that money? Not necessarily, but
probably
not. Boy, would it feel good to have that lien against him.
I'd want to own something of John's. I'd like
couch cushions or
maybe his motorcycle.
I actually don't know what happened to the couch cushions after DabbleCon 2.
I have heard that there was a member of the staff of the venue that had to pick them up and throw them in a dumpster.
Gross. I believe it.
Yeah.
I believe it. Disgusting. Next up, we have Captain Stoned Crab, $1.99. Thank you so much. Luigi, can you post a link to your Friday's show? We will make sure to get that posted, and I will add it to the description of this video also so that everybody can make sure to easily find it if you haven't already found it. Yes.
It is, by the way, I do want to just mention it's this show behind me. It is me and Corndiff and Gummy Chainsaw, and the whole show is about exposing frauds, liars, con men, and grifters, and exposing, debunking the paranormal. And we were on a different topic, a very complicated, interesting topic about a very prolific con man, and I just thought it was the right time to talk about John. So there you go.
I mean, you described him perfectly. Con men, I already
frauds, liars. Yes.
I have a very excitable kitty again. You can tell it's almost bedtime.
Sexy.
Manigan, a Quinn Martin production, $5. Thank you so much. No matter who wrote this legal travesty, wouldn't you think that somebody from the lawyer's office would have proofread the document before filing? He should have.
Fantastic point. Fantastic
legally,
point.
That is what should have happened.
Legally, that is what should have happened.
You are not supposed to practice law if you are not an attorney. And filing a document without the attorney's review and signature would be considered practicing law without being an attorney. Now, is that ever going to be able to get proven? I don't think so. I don't think so at all.
But I do think the context of it falls right in line with what I said earlier, is that John will never pay for a lawyer. He will always get pro bono services, or he will take someone's recommendation for a lawyer, or he will get connected with a lawyer and use them for favors. He never pays for a lawyer. And you get what you pay for, and you get a lawyer who doesn't give a shit about your case, who can't even take the time to spell his own name right.
Yeah.
So there you go.
Yeah, it is very, very true. Well, at this point, I have a kitty cat who clearly wants to go to sleep right now in multiple ways. I think that we are going to conclude this episode unless you have any final thoughts before we get into eventually us talking about the next steps in this case. Any final thoughts on where we're at right now?
Yes. John is dumb. That is all.
Yes, I could not possibly have said it better. I want to remind everybody one more time, go support Luigi Greenberg. Support
Please.
all of the shows that he is doing. Go support Karl on Who Are These Podcasts. Go support Shuli on the Shuli Network, Uncle Rico Show. Watch their shows. Do not skip the ads. If you can, give them money. If you can't, I don't care so much as long as you are liking and subscribing and leaving comments. That stuff matters to us creators so very much. It matters so much. And these people all need support right now.
Don't let John win.
Yes. Do not let John win. Thank you guys all so much for hanging out with us. We cannot wait to see y'all again. And hopefully we will see you next Monday around this time, around the 7 or 8 p.m. Vicinity for the Edge Files with Trucker Andy from All Apologies Podcast. And we'll see you guys all soon. Bye.